Am I audible?
Yes, sir.
Okay, just a second. Okay, so let me know if the screen is visible.
Yes, sir, it's visible.
Okay, great. So today we are going to this is another situation where we are going to start uh, discussion on how to draft a contract. So we are still discussing the draft, the way to draft a contract. But the difference is now this is the critical part, and from here on you will start learning the actual drafting. So, what you are expected to learn in this, that how to begin the draft, how to identify, collect, and verify information, and how to write the effective recitals or background. Then you will learn about different types of definitions and understand how to avoid mistakes and how to draft a precise recital or background and the definitions. And you will also understand the difference between the archaic version and the modern versions. So, when we start the discussion on a contract between two parties, usually we have to identify the parties. For that purpose, we have to identify the party name, their contact details, and the background information relating to the transaction. And if they have negotiated commercials relating to the transaction, then those commercials, which will help us define the recitals, the scope of the contract, and understand what legal clauses we have to include in the contract. What is a legal name? So we all understand that an individual's name is as per his PAN card, Aadhaar card. So you can ask for those documents. In case of a company or partnership, you can ask for incorporation certificate or a partnership deed. In case of company, you can check the details from MC website. That's Ministry of Corporate Affairs website. Then you can ask for GST registration certificate, and the person who will be signing the document or the agreement, in their favor there should be a power of attorney or a board resolution or an authority letter. So as per, if you're working in as an in-house counsel, there may be an internal process which will help you identify what all you need to ask the counterparty before you start the drafting. And in case a contract requires witnesses, then the details of the witnesses. This can be addressed at the time of execution of the contract. Next is the introduction of the contract. The essential elements of the introductory sentence is the type of the agreement or the name of the agreement, the execution date of the agreement or contract, and the effective date of contract. Both these things are different, and then there is place of execution. The sample language that I have suggested, just I'm reading that. This master service agreement, which is defined as agreement, is entered into on so and so date and made effective from so and so date, which is defined as an effective date by and between X and Y. So In this sentence, the first definition is the name of the agreement. When you define the name of the agreement, then it will be used throughout the draft as a defined term. Then the first date is the date of execution of the contract. You can keep it here or at the signature page. It is advisable to keep it in the start because sometimes people forget to put dates while signing the contract. So keep the date current using Microsoft Word's feature of current date. I'll show you how to do that. And then you have to specify the date, which will be the start date of the contract. It can be a date which is a back date, it can be a date which is current date, or it can be a future date. It is also called as commencement date, or it can have any other name also. Next is the legal name of the parties, which we already discussed. Then the for address, it can be a personal address of an individual or a company address. It can be a corporate office address. It can also be a registered office address. In case you are not sure, verify from MCA website for the registered address because people are usually not aware if they have a different corporate and registered offices. So registered office address will be can be found at the MCA website and corporate office address can be asked from the other side or it can be checked from their website also. PAN GST number is an optional item. If you want to include it, it is fine, but it is not necessary. Then the authorized signatory, this is also an optional thing to include in the introductory sentence. Then the defined name of the party. So I'll come to that later. And if there is any archaic language, you should delete that or modify it. In the recital section or the background of the contract, we have to specify how parties arrived at the transaction. What is the information which led them to the current contract formation? It can be recital, it can be a background, it can be an introduction. So heading is immaterial, but basically you have to include the information about the transaction. What to include? So you may include that the parties are engaged in certain business activity or that they require some type of services and the other party is the service provider who's engaged in providing that service and the objective of the contract. So let's say if you are to have a MOU, memorandum of understanding for a future business endeavor, or you want to have a limited scope of service. So depending on that objective, you have to specify the sentence. The most of the Indian contracts you will find the term whereas. Whereas is a archaic language, you should avoid this. You should also avoid using any representation clause within the recital because representation should be clearly identified in a separate clause rather than using them in the recital section because there are cases, at least not in India but outside, where use of representation in recital clause have been held to be invalid. And we can use this part to identify some definition, just like the introductory sentence, where we identified agreement as a defined term, effective date as a defined term. Now let's see what will happen in case there is a complex contract. So in case of a complex contract like shareholder agreement, EPC agreement, we also use interpretation clause. This is optional in simple service contracts, sale contracts, and can be avoided unless it is a very detailed contract and you need clear picture that the interpretation of the contract has to be in terms of the interpretation clause. What is included in the interpretation clause? I'll discuss that later. When to include definitions? So definitions are something that we have to consider in case we are using repetitive identifications. For example, if we write master service agreement 15 or 20 times in the draft, then it's easy to write agreement as a defined term. There are different types of definitions, which will come to that. Where to include the definitions, that is also key, and how to use them, and what are the common mistakes that we should avoid. So, I think this slide is over. Yeah. Now, let me come to the document. Let me know if this slide is visible. Is it visible?
Yes, sir.
Okay. So, this part is the introductory section which we discussed initially. In this, you can see there is a defined term agreement, and then there is the effective date, which is another defined term. Then there is a section of parties. So there are two parties, one is party A, one is party B. Again, party A is a defined term and party B is defined term. Now you will see how we have used this definition in the body of the agreement. There is a collective definition of parties and party. So we may also use this short definition of party or parties throughout the contract. Then there is a background section or recital section. So we have defined the transaction, the recital of the transaction as 1 and 2 and 3 sentence. So party A desires to purchase certain construction equipment for its business. Party B has offered to sell the building construction tool of so and so make and so brand to party A. Now, this building construction tool of this make and brand is defined as goods. Now, see how we have used this definition in this third sentence. Party A has agreed to buy the goods from Party B on following terms and conditions. Is it clear?
Sir, could you explain the second point? Party A is offered to sell the building
So
construction
this
tool of.
this section, building construction tool of make and brand, this is again shortened as a definition called goods. And this goods, the definition goods, is used as goods in third sentence. Party A has agreed to buy the goods from party B on following terms and conditions. Now let's say if in the scope section we say that the goods have to be delivered at so and so place, or the goods have to be delivered by this date, or the goods should be of so and so specification, or they should be of so and so weight. So all those things, when we are saying, we are only saying goods, which will always means building construction tool of so and so make and so brand. Writing a lengthy sentence like this is difficult if we are using it multiple times. But when we are shortening it to a definition called goods, then we can usually use the goods across the contract. So that's why we use definitions to refer to a party or to an agreement or to the start date or to define certain service or goods, and for other things like law and all those things. So we'll come on those later when we in our next classes. Is that clear? Now coming to the interpretation clause. So I have used this article from iPleader's website. I'll just show that to you. Whenever you get time, read this particular article. Is it visible?
Yes, sir.
Now, the interpretation is usually used when there is any lengthy contract that we are entering into. So, this is a general sample of interpretation clause. Now, understand this carefully that this is not an important clause for a simple agreement like sale agreement or service agreement. But sometimes party rely on some way of interpretation which has been established by court decisions. So to make sure that the interpretation is either as per the court decisions or they are in a different manner, then we use this interpretation clause. Now, the first one reads headings are for reference only and have no bearing on the meaning of the agreement. So, sometimes what happens that when you are defining scope of service as a heading, then party may say this is the only clause which is identifying the scope of the entire contract and there is no other obligation. That's why we clearly say that headings are only for reference and they do not bear any weightage on the meaning of the contract. Then there is singular forms of words include plural forms. So by mistake you may use a singular form of word instead of plural. So to clarify that singular includes plural. Gender neutral or gender specific terminology includes each gender. So if you are using gender neutral word like it, they, then that refers to he, she also. A person includes a natural person, joint venture, government agency, partnership, company. So you may use a clause which say that any person representing the other party will be bound by some things, or maybe a party is bound by certain obligations when there is a third person who is acting on behalf of that party. So that person may be an individual person, or maybe a contractor, or maybe a government agency or a company, anybody. It can be a natural or not natural person. Terms such as including, particularly, are not to be construed as words of limitations. So these terms usually define used in definitions. So they should not be limiting the meaning of these sentence. So that's the idea behind using this. Then there are additional ones like All schedules and attachments are included in this agreement, so they have to be read as part of the agreement. The clause, term, party, schedule refers to clause, term, party, schedule, or attachment of this agreement. A party includes its agents, successors, and permitted assigns. So this is the interpretation clause that we use in the contract. Any questions? Okay. So that is all on the uh, lesson. Now let's see one of the contracts. Let me know if this is visible.
Yes, it is, sir.
Now if you see, this is a shareholder agreement between two entities, and they have used one, just a second, definition section and interpretation section separately. Now the interesting part that you will see here is in the main body. This is the name of the contract, amended and restated share purchase and shareholder agreement. Now, you see, this is a lengthy name of an agreement. So what they did, that they shortened it, agreement. Then they have said when it is executed and among whom it has been executed. So it has been executed on May 21st among the company A, which is known as company. Then there is company B, which is known as AIL, and there is company C, which is known as Yunfeng. Now there are three parties in this contract. The interesting thing, that is not a two-party contract, but is a three-party contract, and we'll know why. The company AIL and Yunfeng are parties to certain share purchase and shareholder agreement dated April 21, 2014, the prior agreement. Now we know that there is a prior agreement before this amendment. So basically what they are doing is that they have entered into a shareholder agreement and they are amending it. So that is known as a prior agreement. Then there is second sentence which says, in accordance with the prior agreement, company AIL and Yunfeng desire to amend and restate. So the object of the this agreement is to amendment of the prior agreement. Third says the company desires to repurchase. So there was a purchase, now they want to repurchase all of ordinary shares, par value so and so per share of company held by AIL. So company is wanting to buy the shares of the company which AIL owns, the existing AIL shares, and AIL desire that company repurchase all of existing AIL shares upon the terms and conditions set forth in this agreement. But what is the consideration? In exchange for issuance by the company to AIL of an aggregate this many class A shares. So what they have been doing is that there is an ordinary share of certain value which is owned by AIL, which company will buy, and they will issue an this number of class A shares, so the different class of shares than the ordinary shares, which share shall initially represent this number percentage of the outstanding ordinary shares of the company on a fully diluted basis after giving effect to the issuance of the AIL shares and YF shares as defined below, but without giving effect to any issuance of any AIL additional shares or YF additional shares. Now, AIL additional shares and AIL shares. These are two distinct terms, both have been defined below. YF shares and YF additional shares. These are two distinct terms as defined below. Then coming to the third sentence, the company desires to issue, sell and deliver to Yunfeng, not TAIL, Yunfeng. And Yunfeng desires to purchase and acquire from company upon terms and conditions set forth in the agreement an aggregate of this money of this number of class B shares of the company known as YF shares. So you see YF shares and AIL shares have different meaning. AIL shares is defined here as class A shares of this much number, and YF shares is defined here of class B shares of this much number. So you see how they have used definitions within the recital section and how they have cross referencing these definitions within the recital. So that's how a complex contract will look. Now, without going into detail of the transaction, let's move to the interpretation clause. The definition section will come back to that, but before going to that, let's see interpretation clause. This is a very lengthy contract. You will maybe take time to understand it. Now, this is section 1.2 interpretation and rules of construction. So, what they are saying that in this agreement, except to the extent otherwise provided or the context otherwise requires, so there is a qualification that although these interpretation or manner of construction has to be followed, but this is subject to if there is any statement to the contrary in the agreement or by way of context. So the first one reads, when a reference is made in this agreement to an article or section, that reference is an article and section of this agreement. The heading for this agreement are for reference purposes only and do not affect in any way the meaning or interpretation of this agreement. The words hereof, herein, hereunder, and words of similar import when used in this agreement refers to this agreement as a whole and not to any particular provision of this agreement. All terms defined in this agreement have the defined meanings when used in any certificate or other document made or delivered pursuant hereto, unless otherwise defined therein. So that means a definition will have a define which is used in this agreement. They have a meaning, which meaning will be as per any certificate or document issued or delivered under this agreement, unless that particular definition in the document is different. The definition contained in this agreement are applicable to singular as well as plural forms of such terms. Reference to persons or also to its successors and permitted assigns. Use of term or is not intended to be exclusive. So even if a term has been used that this or that, then this and that is also the meaning in addition to this or that. Now coming back to definitions. Now you see we already discussed YF shares. Let's see. YF shares has the meaning set forth in this recital, in the recitals. Similar way, there will be AIF shares. So here is the AIL shares. AIL shares has the meaning set forth in the recitals. But when you see all other definitions, they have a definition under a particular section of this contract or under a different document. So, for example, when they are saying or AIL UQ shares means following the closing the UQ shares held by the company that are attributable to Class A shares. Then there is definition of bankruptcy and equity exception has the meaning set forth in section 3.1a. But when you are using a beneficial ownership definition or beneficially own or a similar term, that will have a beneficial ownership meaning as defined under Rule 13(d)(3) under the Exchange Act. So whatever be the governing law, depending on that, that act has been identified, and of that act's rule number 13(d)(3) defines beneficial ownership. So the parties have referred to that definition under this contract also. If you see, the definition is used in an alphabetical manner. So basically, it helps in a better reading of the contract, but you can have it non alphabetically also. So we discussed today the parties, the introduction sentence about the agreement, the execution date, and the name of the parties, and then we discussed how to identify those parties. So, like Alibaba Investment Limited, a business company incorporated with limited liability under laws of British Virgin Islands, or YF Venus Limited, an exempted company with limited liability incorporated under laws of Cayman Islands. So we are identifying the parties. Then there is recital or the background of the transaction. Then we saw the definitions, and then we saw the interpretation clause. Any questions? No? Okay. So now that we have covered these sections, let me.
Sir,
Yeah.
sir, I wanted to ask that the word whereas that we
Hmm.
use in recitals,
Hmm.
uh, I am not very sure about the meaning of that word. Like, could you explain a bit about that word, sir?
See, when the contract drafting started, okay, most likely in UK, then the term recital was used. There is an online article also I read somewhere how the word originated. So what was happening is that they, when parties were entering into a contract, they wanted them to recite about the transaction. So what is this contract all about? That's what the parties had to say. Now, when you're saying that, so that term recital caught hold in the, I mean, the formal language of contracts. So, recital or the background, this term was introduced in the written contracts. Now, when I'm saying written contracts, so that means uh, before that there were oral contracts also. So, when the term recital was used in an oral contract, it simply meant that the parties are expected to say something before they formally conclude the contract. So that was the idea behind it. But when the actual writing started, it was captured as a distinct clause in the introductory part of the contract. So after the parties were identified, then they used to write what is the recital, what is the background of this transaction. So that's how it started. I'm sure you understood. If not, let me know.
Uh, sir, then what is the meaning of that word whereas? Can we use another word instead of it?
There is no need for it. I have discussed it in my next lesson. But if you look at it, or maybe in this lesson itself, so if you look at it, let's say coming back to, let me show you. Uh, let's see this particular whereas. Okay. Now in the recital, Instead of recital, you can write background, introduction, anything, or you can write recital, doesn't matter. So far as it is clear that it is the background of the transaction. Let's read the first statement. Whereas the company AIL and
Sir,
yeah,
sir, is it necessary to write this title, or we directly come to the point like whereas and all? We can start after the introduction, like after the party name and all. So we can directly come to as a whereas and not writing this title as a heading.
see why recital is written, that we have to understand. Recital is written to help give a context to the transaction. That context being that parties have something to exchange with each other. So let's say if a party is a service provider, another is a service recipient. So they are just saying that one party is interested in taking the service and another is interested in giving the service. And these exchange of service will happen on so and so terms, which are as follows. So the recital is not mandatory, but it is advisable to have this. This is how the contracts follow a structure. Some contracts, like MOUs, may not have any recitals. Some contracts, like letter of intents, may not have any recital. So there are different type of document. Therefore, they may not have a recital. But sometimes it is very important to give the context of the transaction. For example, let's say there was a contract which was going fine, and one day the parties had a dispute. After the dispute, parties decided to amicably close the matter, and for that they entered into a settlement agreement. Now, that settlement agreement will show how parties arrived at a settlement, why they have to arrive at a settlement, what was the background leading to that settlement. So, it is important to have a recital in these types of transactions. Now, coming back to use or non use of whereas. If we read the first statement, it says, whereas the company AIL and Yunfeng are parties to that certain share purchase shareholder agreement dated so and so, the prior agreement. Let's just remove whereas and say the company AIL Yunfeng are parties to certain share purchase shareholder agreement dated so and so. Does it in any way change the meaning of this statement? No. It only
Yes.
says whereas is what? That there is something that was there. Now we are saying what is there. So we are not saying that something was there, we are saying this is that what was there. So the statement itself is something that was there. So we are only saying the statement instead of using the term whereas and identifying and relating that with that statement. So whereas is not required. Practically, it is not required because it is understood that the recital is talking about the history or the background of the transaction. Is it all right?
Yes, sir.
Okay. So now that we have covered everything under this lesson, from next lesson we will have a detailed review of the contracts, and I'll also start asking you to draft the contracts. I've shared some links. It's basically the link to the article on interpretation clause and also the uh, brief sample of the contract that I showed you. I'll also share one more link, just give me a second, of the agreement that we referred today. Okay. So now coming back to your assessment of what you understood from today's transaction, let's start with you, Shadab. Any questions?
Sir, when we write a legal name, like as we know that when the two companies are doing transaction, whatever thing, we have to write the legal name of that particular company and all.
Hmm.
So if a single person also they do company as a single person, we write the name of that person.
Hmm.
But sir, if suppose that if one firm is there, that is the proprietorship.
Hmm.
So whether we have to write that person name or proprietor name.
See, in my practice, what I have done is that I write the proprietorship name first, and then say, let's say that XYZ firm is a proprietorship concern, okay, and is represented by the sole proprietor, Mr. So and so, son of, resident of, and all that. So, in a way, I am capturing both things, the name of the proprietorship firm as well as the name and details or contact details of the proprietor. So, in that way, there is no confusion. Who is the party? It is a party who has a proprietorship firm, and that party only owns that. So, that becomes very clear because sometimes there is a change of proprietorship to a company or a partnership firm. Sometimes there is a succession issue. So, all those things are taken care of by these statements. Is that okay?
Yes, sir.
Yeah. Coming to you, Pratham. Any questions?
No, sir.
No?
No, sir. Right now,
Okay.
I've asked for it.
So basically the introduction, the definition, the recitals, all that is clear, right?
Yes, sir.
Great. Govinji, any questions? Govinji, any questions? It can be a no also. Yeah, Pratham.
Sir, you talked about representation clause in introduction of agreement
Hmm.
that we should avoid use of legal uh, clause. So what was representation clause there? I don't understand.
Okay,
Sorry, I missed it.
let's say there is a individual service contract, like you are entering into a contract with an artist. So the artist uh, is representing to you that he is or she is skilled in certain art. Let's say they are a singer, and you want that the in addition to any qualification like a certificate issued by a art school, you also have kind of a representation from them that they have the required knowledge or skill. So you take this statement in the representation clause instead of the introduction part, that is the recital. Because what happens is that in case there is a dispute relating to that representation, then the other side may argue that it was only in the recital section, but there was no actual representation from my side. So, reliance on that representation may be difficult to be proved, or the recipient of that service may not be able to successfully plead their case in case of a dispute. So, it is always better to clearly state that representation within a representation clause in the agreement instead of the recital section. There have been some cases. Maybe you can do some research. I'll also see if I can find, then I'll let you know. Not that I know of such a case in Indian context, but there are some outside India cases where this has been a situation.
Sorry to jump in between, sir.
Yeah, I think.
Just curious. So this representation is different, completely different from the representation and warranty clause.
Now understand These two are very different terms. Representation is a matter of fact. Okay. So
Mm-hmm.
when I'm saying I'm representing to you something, then I'm representing to you something that I know of. Okay. But
Mm-hmm.
when I'm saying warranty, then I'm giving you assurance as to the quality or as to the service expectancy that you have. So they are used generally as a common statement, but it is a different term. Representation is different from warranty. So when I
Yeah,
say,
no.
yeah, sorry.
Okay, no. So here, I mean, okay. So first of all, like I missed today's first 20 minutes. Um,
Not
I was
much you
due to
missed,
some
I'm
person.
sure.
Okay, so due to some personal reasons, I missed. So I joined 20 minutes late. So I missed the initial portion of the class, and so that's why I just got when you are explaining this representation thing,
Hmm,
as per like Pratham's query,
hmm.
answering while Pratham's query. So I thought, okay, maybe I'm not so I'm not sure whether you are discussing about the same representation or it is something else.
No, it
So
is same thing.
this is
It is same thing that we are
same thing.
discussing. So
Okay.
what parties do is that in the recitals they say that party A has, for example, in a simple service contract, uh, party A will say that they desire to avail certain services, and party B will give a statement in the recital that party B has represented to party A that they have the necessary skills or the
Mm-hmm.
expertise to provide the service. And the third statement will say that party A, relying upon the representations of party B, has agreed to avail the services on following terms and conditions. So it is better to have a representation statement like this in a representation clause separately. That's what we are saying
Okay.
because there may be a dispute, and in that
Mm-hmm.
dispute, the party B may say that it is only an introduction part. It is nowhere saying that I'm giving you a representation because there is something different when you say that party B is giving a representation specifically in a representation clause, and that statement of representation says that party B hereby represents that it has the necessary skill and so things. But when you're using it in recital, you are only saying party B is relying on these statement. Okay, so it's better
Mm-hmm.
to have a separate one because there are cases outside India at least where if a representation has been used in recital, then they were not enforced by the court. So it is better to have
Okay.
it as separate clause.
Yeah. So basically, the best thing is instead of assuming things, it's always better to express it.
Yes, and also keep it within a separate clause instead of in the recital. Let's keep the recitals very, very fact related, and those facts should be only about the background of the transaction and nothing more.
Mm-hmm. Thank you,
Okay,
sir.
thanks. So coming back to you, Govindji, any questions? Am I audible? Govindji? Okay, I think Govindji is unable to hear me. Satyaji, any questions? Satyaji, any questions? No? Okay, great. So, what we have discussed so far is the uh, information relating to contract drafting instead of an actual contract drafting. Now, the next session, which may be divided in one or two classes, uh, talks in detail about different types of clauses. so it's important that you attend the next session. And we will briefly discuss the boilerplate and scope clause, payment terms clause, and all that. And these will create the body of the contract. Now, by body of the contract, I mean this is something that as a contractor drafter you have to focus, because the scope clause, the payment terms, or any other relevant term is very, very critical to capture the intent of the transaction that parties have foreseen. So you have to be very clear in what you are writing and what you are not writing there. Because when you are including something or excluding something, there has to be a justification for that. So the way it should be done is start in a simple manner, take all the pointers from the client and the counterparty, and keep it very, very basic. And if there is something that they want to add specifically, there has to be a clear instruction from them about including that in the sentences. Now, the boilerplate is something that you can control, but you may have to get into lengthy negotiations with the counterparty's counsel. So there is a possibility. So we have to be very ready to understand the recital, which should be kept simple. So some recitals can be kept neutral. That is, it can be kept bilateral, or it can be stated as a matter of fact instead of as an obligation. But some recitals like indemnity, they have to be very, very clear whether it should be a bilateral one or it should be a unilateral one, and the scope of that uh, particular clause. What type of limitations you want to put on the other side. So all those things we'll discuss in next class. And if you have any questions before, if you miss any part of this today's session, then I suggest that you go back to the lesson and read that lesson first. Then we can have further discussion in next class. Any other questions? Anyone? Oh, okay, great. Thank you for your time. And I was hoping that this session will get lengthy today, but I see most of you have not joined, so we can. I mean, I'm able to close it so soon in 1 hour. Anyways, thank you for your time. Yeah,
Sir, I
yeah.
wanted to know, like, when will you share the recording of today's session? Because since I missed, so I just wanted to, because the agreement which you shared, like while discussion,
Hmm,
I actually I was not even like during the whole session. I was not
hmm.
like I joined the class via my phone instead of laptop, so
Okay,
I wasn't able to read it properly. So
okay.
I just wanted to know, like,
I
when
have
will you share the recording so
Okay,
that I can.
I have shared the links of that contract. It's a public
Mhm.
website. So I have shared the links in the chat box. So you can copy that from the chat box. There are three links. One is of the sample contract that we discussed,
Mhm.
a draft one of the introduction part and the recital. Then there is
Okay.
a article on interpretation clauses. This is
Mhm.
iPleader's website. This is also public link. And the third one is the contract that we discussed, a shareholder agreement. So
Mhm.
these links you should copy. You can refer to them. And the recording I'll be sharing in maybe half an hour.
All right, sir. Okay.
Sure.
So after going through, if I'll have any question, I'll ping you.
Yeah, no problem. Just drop me an email or we can chat on the Telegram group,
Yeah,
or
sure.
maybe in the next class we can take up.
Yeah, definitely, sir. I'll jot down all the questions, whatever doubts I have, and
Sure,
then
sure,
I'll ask.
sure, sure. Thank you,
Thank you.
Aarti ji. Thank you, everyone. Thank you. Bye bye.
Bye.